Senior Moments, sponsored by the Empowering Seniors Group on News Talk KVNU, 102 FM and 610 AM.
Good morning, everyone, and welcome to the Senior Moment Show. My name is Bryce Patton, here with Sid Roeder, who is here this week. Last week you weren't, and so we talked smack about you. So I'm really glad you were here this week.
I guess I'm going to have to go back and listen to that show then.
You may, maybe not. Well, welcome.
Yeah, I'm back. How are you,
excellent.
Bryce?
I'm great, thanks. Well, we have a wonderful guest, and we've been talking a lot already, even before we were starting the show. So do you want to tell us about our sponsor, which he's a part of, and then we'll dive into our guest?
I would be delighted to. We are sponsored by the Empowering Seniors Group, which is a group of professionals that have dedicated their time and effort to provide information to seniors, their family members, caretakers, and all those wonderful people that listen to us every Saturday morning. If you'd like to learn more about the Empowering Seniors Group, you can do so online at empoweringseniors.info, or you can email us at empoweringseniors.cv@gmail.com. Or lastly, you can call me personally at 435-512-6406.
Awesome. Thank you for that. All right. We have Justin Wall with Wall Estate Solutions with us today. And welcome back to the show. We've had you on a few times.
Always a pleasure to be here.
Yes. This one, it's always exciting because you dive into all these things about trusts and wills that, I don't even think about. But we were talking before the show, and we were talking about beneficiary distribution patterns, which is basically a complex way of saying how someone can inherit, right?
Yeah, yep. So when we're looking at beneficiary distributions, whenever we set up an estate plan, we need to know what the situation is with the family, with the finances, and the specific reason for that is we need to know what kind of a distribution is appropriate. So when people think about inheriting, they think, well, I'm going to make sure that my wife gets everything or my husband gets everything or everything goes to my kids in a specific pattern, or maybe they want to leave something to charity. Everybody kind of comes in knowing generally the idea that they have about who gets what, but they don't think about how and when and maybe under what circumstances. And so that's a big part of the discussion we have when people come in to meet about setting up an estate plan.
That's great. And so maybe you can tell us a little bit what some basic rules are for a will or a trust?
Yeah. So we usually start with, the ground level, which is if we keep it as simple as we possibly can, and that's what I compare my work to. If we don't do any estate planning, what is that going to look like? And how can we improve on that situation? Without getting into, without an estate plan, your estate might be in probate, without getting into any of that, just the distribution pattern by default. The statutes will leave everything to a surviving spouse if there is one, and then if there's not a surviving spouse, generally it'll go in equal shares to the children. And then there's distribution patterns if you have a child that's passed away or other situations that come up. But generally that's the situation. Not an issue for most people. That's kind of generally the pattern that most people like anyway. For the most part, of course, if there are exceptions, then we have to do an estate plan to get around that, and that's a benefit for those people. But what people don't often think about is, well, what happens if my child is not in a position to inherit an outright distribution? What if it makes more sense for us to put a restriction on, say for a minor beneficiary? We don't want them to inherit when they're 18 years old if it's a $500,000 estate, right? Or if you have a child that may be going through a disability, or maybe they're not able to manage their finances. Maybe somebody's going through a divorce, or maybe you have a mixed family situation where you have my kids and you have your kids, and we've got to do some special things there. There are a lot of scenarios where we need to think about what would happen if we made an outright distribution to these beneficiaries, and is that really going to be the best way to leave them in inheritance when we have other tools that we can use to set that up?
So what's an example there with somebody, and let's just say, because we've talked about that before the show, if somebody has a substance abuse problem, what's a good way to set that up? Yeah,
great example, because I get this question a lot from folks that have kids with substance abuse issues, and they'll often come in and they'll say, well, we don't want to leave anything to this child because we don't want them to blow the inheritance, and we know what they're going to do with it, and it's not going to be good for them to inherit at all. So their plan when they come and talk to me is to say, well, let's just give the estate to the other kids, or give his share to charity or to his kids or her kids, instead of giving it directly to the beneficiary. And they don't know that there are other ways we could do that. And for some people, that's fine. We want to leave it away from them anyway, sometimes in a way to punish them a little bit. But other people, they say, well, we just don't want him to destroy his own life with this inheritance. And so we sit down, we go through, we say, well, his share, her share, can be treated differently, and we can leave them an equal share with the other children, and then we just take that share and put it into a what we call a subtrust, right? And we say, well, somebody else is going to be the trustee of that subtrust, so they don't get to call the shots on what these funds are used for, even though they've already been set aside for their benefit. So if they come to the trustee and they say, hey, I need some help with a down payment on a house, the trustee can say, that's fine, I will write the check to the buyer. Or if they say, well, I want some help with tuition, or maybe I want some help going into rehab and getting some help handling my situation, the trustee can say, that's fine, we'll pay those bills for you without giving you a check that you can go use and blow in some other way, right? We can write those rules into a trust, and we can tailor them to exactly what the parent or the person talking to me wants to do for their child based on their circumstances and what their objectives are and their wishes. I've had people that come in and say, well, we want to give them a distribution, but we want them to pass a drug screening first. And then we set rules for what kind of a drug screening and how that all works. It really just depends. There's a lot of ways that we could handle that that don't involve disinheriting a beneficiary that you want to leave in as part of the estate.
Are there different time frames with that? Can you distribute multiple times throughout someone's life, or is it just one big chunk of change?
Yeah, absolutely. So that's it depends on what you're trying to accomplish. If you do one big chunk of change, we call that an outright distribution. And again, that's the default. If we don't say anything else and if we don't do anything else, that's typically how people will inherit. But often people come and they say, well, we've got a pretty sizable inheritance here. We're not living rich, but if we sold our house and everything that we own and distribute it between our 1 or 2 kids, we might be looking at $500,000 or $1 million, and that can be pretty substantial. So this is more than just creditor protection for a substance abuse issue. A lot of parents will come and they'll say, well, we want our kids to experience what it's like to inherit $250,000 in 3 different time frames. So the first one they can take and they can learn how quickly that goes. And then the second one, maybe it's a little easier for them to save and manage that money better. And then by the third one, they'll have their ducks in a row. So a lot of people will say 25 and 30 and 35, and we'll just make distributions at different ages. Some people will also say it really depends, and we don't know when we're going to pass away. So why don't we leave it to a trustee and let them decide when a distribution is appropriate? And then it's creditor protected for the kids. If the kids decide, we don't need this right now, then they can leave it and let it grow in an account where it's invested and it continues to grow over time. And then if they need it as a rainy day fund at some point down the line, when they're 50 or 60 or as part of their retirement, then they can access that later on. It really depends. I mean, the sky is the limit when it comes to trust. We can set that up and do it based on what makes sense for the family circumstances.
That's perfect. We're already coming up on our first break. Too little time for me to ask all the questions that you just threw up in my head. So let me just mention our sponsor again, which is the Empowering Seniors Group, a group of professionals that will help you with any senior-related issues. If you'd like to find out more about them, you can do so online at empoweringseniors.info, or you can email us at empoweringseniorscv@gmail.com. We're going to take a short break. Stay tuned. We'll be right back.
Did you know 1 in 3 people will visit a nursing home? Did you know that once there, they will stay there for an average of 3 years? Did you also know there are insurance options that can help cover this experience? Hi, I'm Tracy Ferris with Blue Water Health Insurance. It's not cheap to stay in a full-fledged nursing home. Long-term care insurance can help you or a loved one get the care they need and deserve. If you wait until you need it, you may be too late. Give me a call at 435-890-8155.
Picture this. Your family's locked in court, fighting over your home and your assets because there was no plan. Don't let probate decide your future. I'm attorney Justin Wall with Wall Estate Solutions. Stay in control with wills, trusts, and smart planning that keeps your family out of court and your wishes protected. Get peace of mind today. Visit wallestate.law or call 435-294-0346. That's 435-294-0346. Your legacy, your plan.
Getting around your home should be easy and safe. At RT Med Mobile, they provide wheelchairs, stair lifts, ramps, and electric lift chairs to help seniors maintain independence and comfort. Their friendly team offers free in-home consultations to find the perfect solution for you or your loved one. Locally owned and here to help. Call 435-260-6171 today. RT Med Mobile, because your mobility matters.
This is Mark Thurston with White Pine Funeral Services. The best time to plan is when you have time to plan. Having a pre-arranged funeral gives peace of mind for everyone involved. White Pine will customize your final wishes to fit your needs, from a traditional burial to cremation to a custom headstone. White Pine also accepts pre-arranged plans from other mortuaries, and we will absorb any transfer or revocation fees. No penalty to you. Visit whitepinefunerals.com or come and see us for more information.
White Pine Funeral Services, here when you need us most.
You have a lot of options when it comes to buying or selling a home. Do you list it online, sell it yourself, or do you have a realtor help? It's a major financial and emotional decision. A realtor is the liaison between buyers and sellers and really helps you navigate complex contracts, deadlines, and disclosures.
Hi, this is Sid Roeder with Achievement Realty.
I work for you to get the best outcome for your situation. Let me earn your trust with a free consultation and a free market analysis. Call me today at 512-6406. Then list it, sell it, and move on.
And welcome back to the Senior Moment Show. My name is Bryce Patton here with my co-host Sid Roeder, and we've been speaking with Justin Wall from Wall Estate Solutions about trusts and how complex they are. And if anyone has questions or wants to come see you about setting up a trust or a will or things, what's good contact information for you?
Yeah, best way is to reach me is probably by phone. Number's 435-294-0346. That's 435-294-0346. And that just calls into my business line where you can schedule an appointment and go through your situation.
Perfect. Thank you. And before we hit the break, there were a few questions that came up in my head because you were talking about trustees. And obviously, as a real estate broker, I'm familiar with trustees when it comes to real estate sales. But I'm kind of wondering, oftentimes for things like that, people pick family members. But if they can't or don't want to, how do you pick a trustee and what is the cost associated with that?
Yeah, so two different questions. So picking a trustee, we usually start with, again, what's the path of least resistance and does that make sense? And usually that puts us into the family. If we've got, a family that's, well-oriented, that gets along okay, and then there's somebody that's maybe the oldest child or has experience, usually that's the best choice because they don't usually, we give them the authority to charge a fee, but oftentimes they'll just waive it, and that ends up being a benefit to the estate because oftentimes they're also a beneficiary and they're just saying this is for me to get my inheritance and I can do it for the other kids too. The other side of it is, and there's a whole spectrum here of who you could name as the trustee. On the other side, we have the professional trustees, the corporate, fiduciaries that will serve in that role. Generally, they're going to charge based on an amount of assets under management. Now, this is a matter of contract, so they don't have to do it that way, and maybe you can shop it out and find different trustees that will charge in different ways. But my experience has been for most of the trustees that I've worked with, it's going to be a percentage, and that percentage is going to range based on the value of assets. So it might be if it's a $10 million plus estate, it might be 0.5%. If it's less than $500,000, then it might be 1 or 2%. And so it just depends on the value of the assets and the size of the estate will determine what they charge.
So a quick question along with that. So these trustees, these professional ones, do they have some sort of an education that qualifies them to be that?
Generally, they'll have a background in finance. There are designations that they can get to show that they have professional status. But at the end of the day, there's no legal requirement for you to name a trustee that has any qualifications. As long as they're well suited to that purpose. I mean, we're not going to name, your kindergarten teacher who doesn't have any finance training to be the trustee. That's more a practical issue than a legal one. So usually, they're in the banking world, they're in the financial advisor world, they're in the legal world, dealing with trusts on a regular basis. And most of the ones that I deal with, it's either a company that this is what they do, or they're a division of the company and the employees of the trust section of this company, that's what they do. So just as a matter of qualifications, they're very well versed in what trust law is and how to manage a trust, and this is what they do for a living. So experience is generally what I look for if we're going that route.
So I'm curious on this. Is there ramifications for a trustee that doesn't manage well?
Yeah, absolutely. So if a trustee doesn't do their job, and I'm talking about what we call fiduciary duties, you're managing assets on behalf of another party that's paying you to manage their assets for them. And as part of that relationship, you're going to have duties of loyalty. You're responsible for those assets. You're going to have duties of confidentiality. For the fiduciary role, you have to manage their assets in a way that would benefit them and not yourself. You're putting their needs above your own in order to get paid that fee and to perform that service. And a lot of litigation surrounding probate and trust litigation actually deals with whether the fiduciary carried out his or her responsibilities appropriately. And so if there's a trustee that, we had one a couple years ago where we had a trustee that just didn't act. He just sat on it for 1.5 years, and then my beneficiary client came to me and said, well, we have a trustee that's not doing anything. What can we do? We took it to court. We didn't sue for any criminal sanctions or anything like that, but we can file a suit that says we want this guy removed and we want to appoint somebody else, which is exactly what we did. And the judge had no problem removing this trustee and appointing somebody else to get the job done. So they do have to carry out what the trust tells them that they're going to do. Otherwise, they shouldn't agree to serve as the trustee in the first place.
So with family members, is there a way to swap them back and forth? As a trustee, like you have a big brother that everyone thought would do a great job and he's not, and the other siblings are all like, hey, he's not doing a very good job. We might need to vote him out of here. Is that possible?
So we can write that into the terms of the trust. There's no reason not to. What I'll usually say is, because usually I'm not working with the kids. I don't meet the kids. I meet the parents, and they're naming one of their kids who they think and they trust to be in a good position to do that. At the basic level, nobody has to serve. So I tell my clients, if you name this person because they're your first choice and they're not able to, or they're not willing to, or they're living in another state and they think it'd be a hassle, then they just sign a paper that says we decline to serve. And then we move to the next person in line. And then we say, well, if that happens, who's your next choice? And we can go through that. Now, that kind of depends on them willingly giving up their authority to serve as the trustee, which your question was more about, well, what happens if they're acting out of line, right? And at some point, if they're talking to each other, they can figure it out, but it's still going to involve either the trustee stepping down and somebody else stepping in to take his place, or we might have to take court action if they're not willing to do that or if they're not responsive, because nobody else is the trustee as long as that person is serving, unless and until we get someone else appointed.
Wow, that all sounds so complex that I can't shake the question. How many times in your experience, if you had to put it in percentage, does that happen peacefully? And how many times does it not happen peacefully?
Well, so in terms of how often, per case, it doesn't happen very often. But in terms of the time spent, we spend a lot more time working on those cases where we have trustees that are acting out of line than we do with the trustees that are fully cooperative, just because it takes more time and more effort and more expense to deal with somebody that's not fulfilling their role as the trustee.
Now, when someone comes to visit you, then do you walk through who's going to be, and you talk them through, hey, think about the trustee, and these are some of the qualities, and you kind of teach your clients on how to pick somebody up?
every time, because it's critical. That's one of the main components of any estate plan is who's gonna carry this all out. If you want everything to go to your kids in equal shares and yada yada, that's fine, but somebody needs to be there to sign the checks, because by definition you're not there to do that. So it's got to be somebody that's on it. And I'll talk to my clients about that. We'll go through what the qualifications are going to be, and they'll usually have someone picked out by then anyway. It's really a basic portion of the estate plan.
Really quick before we go into our second break, when is it more advisable to have a trust than a will?
Yeah, great question. I think that most of the time, a trust is going to be the right scenario if you have multiple kids. And I think every practitioner kind of has a different standard. I know some that will say, it doesn't matter. You're always going to want a trust because a will doesn't avoid probate. Fair enough. But I can write a will, and then we can create beneficiary designations on all of your assets, which works out pretty well if we have a single individual child. If we have multiples and we're saying, well, we've got to leave this house 3 ways to 3 kids, that's all well and good, and that avoids probate. But now we have a house or a ranch or a piece of property that's owned 3 ways by 3 children, and that can create its own problems.
Great. We're already coming up on our break here. Justin, maybe one more time, your phone number in case somebody has questions for you directly.
You got it. So best way to reach me, 435-294-0346. That's 435-294-0346.
Thank you. This is the Senior Moment Show. Again, we are sponsored by the Empowering Seniors Group. If you'd like to learn more about them, you can do so online at empoweringseniors.info. We're going to take another break. Stay tuned. We'll be right back.
Are you tired of feeling unwell and not knowing why? At Next Level Health and Wellness, we hear you. We specialize in uncovering the root causes of your discomfort, whether it's gut health, hormone imbalances, or emotional and mental blocks. With personalized plans, advanced lab testing, and evidence-based holistic nutrition practices, we guide you toward lasting health and wholeness. Awaken your healing potential with a team that listens, understands, and supports you wherever you are. Visit nextlevelhw.com to start your journey to feeling better today.
Picture this. Your family's locked in court, fighting over your home and your assets because there was no plan. Don't let probate decide your future. I'm attorney Justin Wall with Wall Estate Solutions. Stay in control with wills, trusts, and smart planning that keeps your family out of court and your wishes protected. Get peace of mind today. Visit wallestate.law or call 435-294-0346. That's 435-294-0346. Your legacy, your plan.
It's tough knowing how to care for an aging parent. Mom has always been there for me, but now I need to be there for her. When we found out she needed surgery, I wondered how I could attend to her needs and still be mom to my kids. I was so relieved to learn about transitional rehab at Maple Springs in North Logan. From the nurses to the physical therapists, it was like their whole staff was focused on helping Mom get better. Maple Springs in North Logan was an answer to my prayers.
Learn more at maplespringsnorthlogan.com or call 753-9400.
Need a helping hand? The Bear River Association of Governments, also known as BRAG, is here for you.
They assist seniors with in-home services, provide utility bill relief through the HEAT program, and offer rental assistance to keep you housed.
Need help with tax prep? Their experts ensure you get the refund you deserve. And for veterans, they're here to connect you with the benefits you've earned.
BRAG is your local resource for a stronger today and a more secure future. Call today or visit brag.utah.gov.
This is Oliver with Cache Valley Pharmacy. We're working with Cache Valley's own Focus Pharmacology and CacheMedical.org to help you lose weight the right way with supplements that support your weight loss journey and easy telehealth appointments from the comfort of your own home. When you think weight loss, think Cache Valley Pharmacy, your partner for a healthier, more confident you. Visit us at CacheValleyPharmacy.com or go to CacheMedical.org to start your weight loss journey today.
Hi, this is Bruce with Comfort Care. One of the ways we help loved ones stay in their home is by assisting with daily tasks. These may include bathing, meal preparation, medication reminders, and housekeeping. We even help with shopping, transportation, and errands. Most of all, we offer a trusted level of care. Let us help you live your best life possible with Comfort Care. This is Bruce, and you can call me at 754-7676. Comfort Care, 754-7676.
And welcome back to the Senior Moment Show. My name is Bryce Patton here with Sid Roeder. And we've been talking with Justin Wall from Wall Estate Solutions. And you've been talking about how to distribute assets to the beneficiaries. But let's talk a little bit about how to protect those assets and different ways you can do that.
Yeah, great question. So this gets into a specific style of distribution that I don't think a lot of people realize is even a thing. And that's, well, how do we make sure that the assets we leave to the beneficiaries don't get taken away by some third-party creditor? So you might have a child who goes through a divorce, or maybe they get into some financial trouble because of medical bills and they end up in bankruptcy, or maybe they're getting sued, right? So in all of those situations, you've got somebody out there who's coming to claim the assets that belong to your child. Okay. Now, if they've inherited from you, and this all happens after you pass away, if it goes to them as an outright distribution, generally it's going to go right into their name, which means it's going to be subject to those creditors. And now if we have to go through a bankruptcy, they're going to lose their inheritance that you've worked so hard to leave for them, and they're going to lose that in a way that can be protected, which is where we get into what we call subtrusts, right? So when we set up a trust, one option is to make an outright distribution or to set it up, over timed distributions where it goes into their name. Another option is to say, well, let's create a trust for the beneficiary. And the reason this works is because if I gift you an asset, then you own it, right? And you own it the same way as if you had always owned it. It's just your property. But if I gift you a trust, well, now you have a fiduciary obligation as the trustee to follow the terms of the trust. So if I write in terms of the trust that say, yeah, you're the beneficiary, you can use this for your purposes, but not for the benefit of your creditors. If we do that just the right way, well, now they, as their own trustee and their own beneficiary, are not allowed to leave those assets to creditors. So now if they go through a bankruptcy or a divorce or lawsuit, we can't stop them from getting sued, but we can protect the inheritance so that if that ever happens to them after they pass away, those assets are not subject to those creditors, and they're there as sort of a rainy day fund that they can use when they like.
That just actually brought me to a sideline question. How does that work if parents leave an inheritance to a child that's married? Is the spouse entitled to shares there or no?
Yeah, so an inheritance is, by default, it's going to go to the child as separate property. Okay, so we don't necessarily need a trust in order to protect from a divorce, but as a practical matter, what's that child going to do with that check, right? They're going to put it into a joint bank account, and now it's commingled, and if they get divorced in 5 years or 10 years, nobody's going to ask, nobody's going to care. It's just going to be part of the marital pie. So as part of the separate subtrust, we're saying, okay, this is your trust and not your spouse's trust. So it stays off the table. It stays in their name unless and until they pull it out of the trust to use it for their purposes. There's nothing stopping them from using it with their spouse necessarily, unless we put that into the trust. But generally, it stays their separate property because it's in a separate account and it's not commingled with joint assets with the spouse.
Do those get pretty messy when you're starting to get that if you don't have a trust in place? If you
Divorces
don't have it
or-
set up? Well, just the assets, the asset delegation with spouses and different
They
things.
can,
like
yeah, and this may be a better question for a family law attorney, but usually when we're going through, when other attorneys go through divorce proceedings, one of the big questions is, what is separate property? What is joint property? Who owns what? And how are we going to divide this all up? And that can be relatively complicated. It just depends on the financial circumstances and how they've divided the assets. But yeah, probably a question for a family attorney.
So, Justin, that brings up another question to me. You've mentioned these subtrusts and that you can make sure that the benefit really only goes to your child and not to the child's spouse if there is any concern about divorce, things like that. Mm-hmm. So I'm wondering what happens if let's just say I inherit some money and I decide to turn that into something else, for example, real estate, and I do want to honor what's in the trust, that it's not going to my husband at some point down the road. How do I do that?
Yeah, real problem, because if you inherit and now you buy an asset, in Utah by default it's going to be joint tenancy and it's going to be owned with your spouse. So what we do in cases like that is we say, well, if you want to honor the intent of your parents, which by the way, by that point you don't have to. If you want to do it joint, you can. But if your goal is we want to maintain this as a separate asset, then you just use the funds in the trust to purchase a piece of real estate in the trust. So the house can be owned by the trust and you're still the trustee and it's still your property. It's all in your name. Your spouse can still live there. Your kids can still live there, but they're living there because they are attached to you and that's your separate property. So in that sense, yeah, you could, it's very similar to writing a separate property deed, except in the trust, you don't get to pull it out by accident. If you're going to pull it out of the trust, we need to sign paperwork. You need to deliver the property into your name, especially with real estate, since that's all recorded and it's all tracked by the deeds. Very, very, very secure in terms of maintaining it as your separate property if that's your goal.
Right. So, I mean, just to have that clear, maybe from a real estate perspective, the purchase would be under the name of, but then when it's deeded, it goes directly into the trust,
So,
correct?
yeah, the deed goes into the name of the trust with the trustee as the one signing the documents.
And then what if that property is then sold? Does the money just go right back into that
So
same
the
trust?
Yeah, so the trust sells the property. The proceeds come to the trust as the seller, just the same as it would in a personal bank account, except it's all set aside in the subtrust.
Wow, I sure hope a lot of people have been listening because I hadn't thought that one through. Makes perfect sense now that I've heard it. So again, we only have a minute left. Justin, any other thoughts? And if not, we for sure need your contact information again, because maybe you just got some people thinking.
Yeah, well, happy to help anyone that has questions. I do offer free consultations, so if anyone wants to call and just ask their questions, feel free to do so. Number's 435-294-0346. That's 435-294-0346. Call for general questions, or if you want to set up a consultation, it's going to be the same number.
That's perfect. And if somebody wants to sit down with you, do you have an office where you can meet with people?
I do. My office is at 701 South Main Street, down by the Walmart at the Y on the south end of Logan.
Thanks, Justin. It was great to have you here, and I think we learned a lot. I learned something again, which is fabulous. This is the Senior Moment Show. Again, we are sponsored by the Empowering Seniors Group. If you'd like to learn more about the Empowering Seniors, you can do so online at empoweringseniors.info. We're at the end of our show. We hope you tune in again next week.